I didn't say a word when the HOA president started screaming about property values and unauthorized vehicles. I just slid the original 1967 county easement document across the mahogany conference table and watched their lawyer's face drain of color as he read the survey coordinates. 23 years of homeowners association meetings, and not one of them had bothered to check who actually owned the 30-foot strip of asphalt they'd been calling their private road before all this. Started life was exactly what I'd hoped it would be when I moved to Willowbrook Estates. I'd bought the house at the end of Cedar Lane 3 years after my divorce was finalized, looking for somewhere quiet to put my life back together. The place wasn't fancy, a modest 2-story colonial on 2 acres, with mature oak trees that dropped enough leaves every fall to keep me busy for weeks. I liked that. I liked having something productive to do with my hands after spending 40 years behind a desk managing insurance claims. The neighborhood was the kind of place where people minded their own business, where I could spend Saturday mornings working in my garage without anyone stopping by to chat unless they actually needed something. My daily routine was beautifully predictable. Coffee on the back deck at sunrise, reading the paper while listening to the Cardinals argue in the maple tree. I'd spend most mornings either puttering around the property fixing things that didn't really need fixing, organizing tools that were already organized, or driving my 2019 Ford F250 into town for errands. That truck represented something important to me. I'd bought it cash the month my divorce was final. The first major purchase I'd made in 25 years without having to discuss it with anyone. It wasn't flashy, just a reliable work truck in basic white, but it was mine. Kept it clean. Serviced on schedule, parked it in my driveway every night in the exact same spot. The neighborhood was governed by Willowbrook Homeowners Association. Standard stuff, no. Pink houses, no boats in driveways, keep your grass cut. I paid my dues on time, attended the annual meeting, voted for whatever seemed sensible. The board members were mostly retirees like myself, people who wanted to maintain property values without getting too crazy about it. Or so I thought. Everything changed when Margaret Hutchins got elected HOA president. Margaret had moved to the neighborhood 2 years after I did, bought the biggest house on the most prominent corner, and immediately started attending every board meeting with a 3-ring binder full of suggestions for improvement. She had opinions about everything: the color of mailboxes, the height of hedges, whether decorative gravel constituted a landscaping enhancement or a maintenance violation. Most of us just nodded politely when she spoke, figuring she'd calm down once the novelty wore off. We were wrong. The first violation notice appeared on my front door on a Tuesday morning in October. I'd been in the hospital for 5 days getting my gallbladder removed. Routine procedure that turned complicated when they found more inflammation than expected. My truck had been sitting in my driveway the entire time, exactly where I always parked it, exactly where it had been parked for 3 years, without a single complaint. The notice was typed on official HOA letterhead and taped to my door with enough masking tape to seal a cardboard box. Violation of community standards, section 4.7, commercial vehicle parking. Your Ford F250 truck constitutes a commercial vehicle and cannot be parked in residential driveways overnight. You have 72 hours to relocate this vehicle or face a $50 daily fine. I stood there in my pajamas and bathrobe, still moving carefully because of the surgical incisions, reading this thing 3 times before it sank in. Commercial vehicle? I'd owned the truck for almost 4 years. It was registered as a personal vehicle, insured as a personal vehicle, and had never been used for any kind of business. It was just a truck. A regular pickup truck parked in my own driveway. I called Margaret's number that afternoon. Once I'd gotten some real clothes on and felt human enough to have a reasonable conversation, she answered on the first ring like she'd been waiting. For my call, this is about the truck notice, I said. It must be some mistake. I've been in the hospital, and it's not a commercial vehicle anyway, Mr. Davidson. The bylaws are very clear about vehicles over a certain weight classification. Your truck exceeds the gross vehicle weight rating for residential parking. Margaret, it's a regular pickup truck. I drive it to Home Depot and the grocery store. There's no commercial signage, no company registration, nothing. The size of the vehicle determines the classification, not how you use it. The violation stands. Something in her tone told me this conversation wasn't really about the truck. This was about establishing territory, about testing how far she could push people. I'd seen it before in the insurance business, people who mistake authority for power and push until they find resistance. Okay, I said. Let me review the bylaws and get back to you. You have 72 hours, she said, and hung up. I spent that evening reading every page of the Willowbrook Homeowners Association bylaws, covenants, and restrictions. It was 43 pages of dense legal language that I should have read more carefully before buying the house, but most of it was standard stuff. The section Margaret cited did exist. Buried on page 31 in a paragraph about commercial vehicles. But the definition was so vague, it could have applied to almost any pickup truck or SUV in the neighborhood. More importantly, there was no enforcement mechanism described anywhere in the document. No appeal process, no graduated penalties, no procedure for determining what constituted a violation. I printed out the relevant sections, highlighted the ambiguous language, and drove over to Margaret's house the next morning. She lived in a massive Tudor-style house with a circular driveway and professionally maintained landscaping that probably cost more per month than my mortgage payment. Her own driveway contained a Cadillac Escalade that was at least 2,000 pounds heavier than my truck. She answered the door wearing a tennis outfit and holding a coffee mug with "World's Best Mom" printed on the side. Behind her, I could see into a living room that looked like a furniture showroom. I'd like to discuss the truck situation, I said, handing her the highlighted bylaws. This section seems pretty subjective, and I'm not clear on the enforcement. Procedure, she glanced at the papers without reading them. The board voted on this issue. The violation stands. When did the board vote? There's no record of a board meeting in the last month. We held an emergency meeting to address the violation. Was this meeting announced to the membership? Bylaws require 48 hours notice for all board meetings. For the first time, Margaret looked slightly uncomfortable. This was an emergency situation requiring immediate action. My truck being parked in my driveway for 5 days while I was in the hospital was an emergency. She handed the papers back to me. Mr. Davidson, you can appeal this decision at the next quarterly meeting. Until then, the violation remains in effect. I drove home feeling like I'd just been dismissed by a particularly condescending customer service representative, but I also felt something else starting to build. Not anger exactly, but a kind of cold focus I remembered from my working days when dealing with insurance fraud cases. When someone lies to your face with complete confidence, assuming you're too stupid or too lazy to check their claims. That afternoon I started making phone calls. First, to the county clerk's office, requesting copies of all recorded meetings and votes by the Willowbrook Homeowners Association for the past 6 months. Then to the State Association Registry, asking for copies of the original incorporation documents and any amendments to the governing bylaws. Then to my neighbor Jim Morrison, who'd served on the HOA board for 8 years before Margaret took over. Jim came over that evening with a beer and 20 years' worth of institutional knowledge. We sat on my back deck while he explained how things really worked. Margaret's been pushing boundaries since day one, he said. Last year, she tried to ban all lawn ornaments, including American flags. The year before that, she wanted to require approval for any exterior paint color, even if you were painting the exact same color that was already there. Most of us just ignore her more ridiculous ideas and vote them down at the annual meeting.
Right.
This truck thing is different, I said. She's actually trying to enforce it. Jim nodded. She's been looking for a test case. Someone she thinks won't fight back too hard. You're new. You live alone. You don't make waves at the meetings. She picked wrong, good, Jim said, 'cause I'll tell you something else. 3 other people on this street drive trucks bigger than yours, but they're all friends of Margaret's tennis group. Over the next 2 weeks, while I was recovering from surgery and dealing with mounting daily fines that now totaled $700, I did what I'd always done when facing a complex problem. I gathered information. I requested copies of every property deed in the subdivision from the county recorder's office. I pulled up the original 1967 development plan from the County Planning Commission archives. I studied survey maps, zoning records, and infrastructure Development reports dating back to when Willowbrook Estates was nothing but farmland and timber. What I found was interesting. Very interesting. The subdivision had been developed on a 127-acre parcel that was originally part of the Willowbrook farm, owned by the Morrison family from 1923 to 1965. In 1965, Harold Morrison, Jim's grandfather, sold the land to Piedmont Development Corporation with a very specific condition. Harold owned an additional 47-acre parcel on the other side of Willowbrook Creek that he wanted to keep as farmland. The problem was that this retained parcel would be completely landlocked once the subdivision was built, with no legal access to any public road, so Harold negotiated an easement, a permanent, irrevocable right-of-way that would give him access from his retained farmland, across the future subdivision to Cedar Lane and the public road system. The easement was 30 feet wide and ran along what would become the main entrance road to Willowbrook Estates. In exchange for granting this easement, Piedmont Development agreed to build and maintain the road at their expense, with the understanding that it would eventually be maintained by whatever homeowners association was established for the subdivision. But here's what made it interesting. When Harold Morrison died in 1978, his 47-acre parcel didn't go to his son, Jim Morrison's father, who wasn't interested in farming. Instead, it went to Harold's nephew, Robert Morrison, who lived in Virginia and planned to use it as a hunting retreat. Robert held on to the land for 30 years, paying taxes and occasionally visiting, but never developing it or living there permanently in 2008, facing financial difficulties after a messy divorce. Robert Morrison sold his 47-acre parcel to a private buyer who planned to build a single residential home on the property. That buyer was planning to use the easement access road to reach his land. But the recession hit, and the development never happened. The new owner held on to the property for a few years and sold it in 2011 to someone who wanted it for weekend camping and hunting. That someone was me. When I bought my house in Willowbrook Estates, I thought I was just getting a nice toker lot with mature trees and a quiet neighborhood. What I didn't realize, because my real estate agent, the title company, had focused on the main property and glossed over the additional paperwork, was that I had also purchased a 47-acre hunting tract on the other side of Willowbrook Creek, along with a permanent easement that gave me legal right away across the main entrance road to the entire subdivision. I owned the road. Not just a right to use it, but actual legal ownership of the 30-foot strip of asphalt that every single resident of Willowbrook Estates used to reach their homes. The Homeowners Association had been maintaining my road for 15 years. Without realizing it, I sat in my kitchen at 10 o'clock on a Tuesday night, surrounded by survey maps and legal documents, and started laughing. Not the bitter laughter of someone planning revenge, but the genuine amusement of someone who'd just realized they'd been holding a royal flush. While everyone else argued over who had the best pair of twos, the next morning I called my attorney. Not to threaten anyone or demand immediate action, but to make sure I understood the legal implications of what I'd discovered. Sarah Chen had handled my divorce 3 years earlier and had a reputation for being both thorough and creative when dealing with complex property issues. "This is fascinating," she said after reviewing the documents. "You essentially own the only legal access route to 127 residential properties. The HOA has been maintaining your private road with homeowner dues for 15 years. What are my options?" Well, you could demand reimbursement for road maintenance costs dating back 15 years. You could charge a toll for access. You could grant or deny permission for any modifications to the road surface. Or you could simply revoke access entirely, which would make every house in the subdivision legally landlocked. That seems extreme. It would be, but it's also completely legal. The easement gives you control over how the road is used, maintained, and accessed. The Homeowners Association has no legal standing to regulate your use of your own property. I thanked Sarah for her analysis and told her I'd get back to her about next steps. But I already knew what I was going to do. The next HOA board meeting was scheduled for the third Thursday of the month. According to the bylaws, any homeowner could request time on the agenda to address the board, provided they submitted their request in writing at least 1 week prior to the meeting. One submitted my request that Friday, asking for 15 minutes. To discuss property access and maintenance responsibilities, Margaret called me the following Monday. "What's this agenda item about, Mr. Davidson?" "I'd like to discuss some property issues with the board." "Is this about the truck violation? Because that issue has been resolved." "Your vehicle was towed last week in accordance with association rules." This was the first I'd heard about my truck being towed. I walked outside and sure enough, my driveway was empty. My truck was gone. "When was it towed?" I asked. "Thursday afternoon. You received proper notice of the violation and failed to comply. The association exercised its right to remove the vehicle at your expense." I felt something cold and sharp settle in my chest, not anger, something more focused than that. "Margaret, what gave you the authority to have my truck towed from my own driveway?" "The association bylaws clearly state that vehicles in violation of community standards can be removed at the owner's expense." "Which section?" There was a pause. "I'll have to look that up and get back to you. I'll see you at Thursday's meeting," I said, and hung up. That afternoon, I called Jim Morrison and asked him to review the association bylaws one more time, specifically looking for any language that gave the HOA authority to remove vehicles from private property. We spent 2 hours going through every section, every amendment, every revision that had been made since the association was incorporated in 1982. There was no such authority, none. The association could fine homeowners for violations. They could place liens on properties for unpaid fines. They could take homeowners to court for enforcement, but they had absolutely no legal right to remove personal property from private driveways. "She had your truck stolen," Jim said. "That's not association enforcement. That's theft." Thursday night arrived with an early November chill and a room full of homeowners who'd heard rumors about some kind of dispute involving trucks and towing. The community center meeting room was more crowded than I'd ever seen it, with at least 40 people scattered across folding chairs that were usually half empty. Margaret called the meeting to order and went through the standard agenda items: budget, reports, landscaping updates, a discussion about holiday decorations. When she reached new business, she glanced at her notes with obvious reluctance. "We have a request from Mr. Davidson to discuss property access and maintenance responsibilities." "Mr. Davidson, you have 15 minutes?" I stood up and walked to the front of the room, carrying a manila folder that contained copies of documents I'd been studying for 3 weeks. I didn't feel nervous. I felt calm and prepared, the way I used to feel before presenting findings in complicated insurance fraud cases. "Thank you for giving me time to address the board," I said. 3 weeks ago, I received a violation notice about my truck being parked in my own driveway. Last Thursday, while I was at a medical appointment, that truck was towed from my property without my permission, and apparently without any legal authority to do so. Tonight, I'd like to discuss why that action was both illegal and financially problematic for this association. I opened the manila folder and pulled out the first document, a 1967 survey map showing the original Willowbrook Estates development plan. This is the original county survey for subdivision filed in 1967, as you can see. The main entrance road, the road that every single household uses to access their property, was built on a 30-foot easement granted by the original landowner, Harold Morrison. A few people leaned forward in their chairs. Margaret was watching me with a tight expression, but she hadn't said anything yet. The easement was granted to provide access to a retained 47-acre parcel that would otherwise be landlocked by the subdivision development. When the easement was granted, ownership of the underlying land remained with Harold Morrison and his heirs. The road was built by the developer and has been maintained by our homeowners association. But the land itself was never transferred to the association or to the county. I pulled out the second document, Harold Morrison's original deed and the 1978 probate records. When Harold Morrison died in 1978, his retained 47-acre parcel, along with the easement rights, passed to his nephew Robert Morrison. Robert held the property for 30 years and sold it in 2008. The property changed hands again in 2011 when it was purchased by someone who planned to use it for weekend recreation. I paused and looked around the room. Most people were listening intently, though I could see some confused expressions. Margaret had gone very still. That person was me. The room got quiet. It's really quiet. When I purchased my home in this subdivision 3 years ago, I also unknowingly purchased a 47-acre tract on the other side of Willowbrook Creek, along with a permanent, irrevocable easement that gives me legal ownership and control of the 30-foot strip of land that contains our main entrance road. I pulled out the final document, the current county deed and survey map with my name on it. Ladies and gentlemen, I own the road you all use to get to your houses. Our homeowners association has been maintaining my private road with your dues money for the past 15 years. And last Thursday, the HOA board authorized the theft of my personal vehicle from my own property, apparently without understanding the legal implications of that decision. The silence stretched long enough that I could hear the heating system cycling on. Margaret was staring at the documents like they might burst into flames. Now, I continued, I'm not here to cause problems for anyone. I like this neighborhood. I like living here, and I have no interest in disrupting anyone's quiet enjoyment of their property. But I do want to resolve this truck situation in a way that respects both my property rights and the association's legitimate authority. Margaret found her voice. We'll need to have our attorney review these documents. Of course. I've prepared copies for everyone on the board, but I'd like my truck returned immediately, and I'd like the association to acknowledge that it has no authority to remove personal property from private driveways. The meeting devolved pretty quickly after that. Margaret tried to table the discussion until legal counsel could be consulted. But several homeowners started asking pointed questions about what this meant for their property values and access rights. Jim Morrison asked why the board had authorized vehicle removal without consulting the association's attorney. Someone else pointed out that if I really owned the access road, the association might be liable for 15 years' worth of unauthorized use and maintenance. It took 3 weeks for their attorney to confirm what I already knew. The association had no legal standing to regulate my use of my own property, no authority to remove vehicles from private driveways, and no valid claim to ownership or control of the main entrance road. More importantly, their towing company had removed my truck without proper legal authorization, which made the association liable for both the theft and any damage that occurred during the towing. In storage, my truck was returned on a Tuesday afternoon, delivered to my driveway by a very apologetic towing company operator, who spent 10 minutes inspecting it for damage and asking me to sign a release form. There were some minor scratches on the tailgate and a small dent in the rear bumper that hadn't been there before, but nothing major. The following Thursday, Margaret Hutchins submitted her resignation as HOA president, citing personal commitments that require more time and attention. 2 other board members resigned the same week. The association's attorney sent me a formal letter acknowledging my property rights and apologizing for the misunderstanding regarding vehicle removal. But the most satisfying moment came 3 weeks later, at the emergency meeting called to elect new board members and address the access road situation. I sat in the back of the room and listened to 45 minutes of discussion about how to properly compensate me for road maintenance, whether the association needed to negotiate a formal license for continued use of my property, and what safeguards should be put in place to prevent future violations of homeowner rights. The new board presidenta, RETIRED engineer named Tom Bradley, who'd lived in the neighborhood for 12 years, asked if I had any specific requirements for resolving the UA access issue. Stood up and looked around the room at neighbors I'd been living near for 3 years, most of whom I'd barely spoken to before this whole mess started. I don't want compensation for past road maintenance, I said. I don't want to charge tolls or restrict access. I just want to park my truck in my own driveway without getting violation notices. And I want to make sure this association never again assumes it has authority it doesn't actually possess. Tom nodded. That seems completely reasonable. Is there anything you'd like in writing to formalize the access arrangement? Just a simple acknowledgement that the association will continue maintaining the road as it always has, that I'll continue allowing access as I always have, provided there are no further attempts to regulate my personal property without proper legal authority. The motion passed unanimously. These days, life in Willowbrook Estates is quiet again. I park my truck in the same spot in my driveway every night, and no one complains. I pay my association dues on time, attend the quarterly meetings, and vote on issues that affect the neighborhood. The new board members are reasonable people who understand the difference between maintaining community standards and overstepping legal boundaries. Margaret moved away 6 months after the road incident, selling her house to a young family with 2 kids who actually use their driveway for parking instead of showing off. The new residents wave when I drive past, and their children sometimes stop to pet the stray cat that's adopted my back deck as its afternoon napping spot. I still own 47 acres of woodland on the other side of Willowbrook Creek, and I still hold the easement that gives me control over the subdivision's main access road. But mostly, I just enjoy my coffee on the back deck every morning, listen to the cardinals argue in the maple tree, and appreciate living somewhere quiet enough to hear myself think. Sometimes the best revenge is just getting your truck back and making sure everyone owns the road.